Hello, and welcome to another video in Deloitte's IR35 series on the journey to April 2020. My name's Jamie Segura. In this video, we'll look at resolving disputes in relation to employment status assessments and what rights the draft IR35 legislation proposes to enforce this. Status Determination Statements, or SDSs, are notifications confirming the results of the status assessments reached in respect of workers using personal service companies. Clients will be required to provide the SDS directly to the worker, as well as to other parties in the supply chain. Where the worker or the deemed employer disagree with the outcome of the status determination, they may make representations to the end client that the conclusion reached in the SDS is incorrect. This is most commonly expected to be cases where they believe an outcome should be self-employed when a conclusion of employment has been reached by the end client. Representations made to the end client should be as complete as possible to enable the client to give them serious consideration. The end client then has 45 days from receipt to consider the representations and either A. If it maintains its assessment was correct, it must provide reasoning why, or B. If it accepts the representations, it must issue a new SDS stating the new outcome and that the original SDS is withdrawn. There is no further right of appeal following the end client's decision on representations made. If the end client does not respond to representations within 45 days, then the draft legislation provides that the end client will then become liable for pay as you earn and NIC, where IR35 applies, if they were not already. What this means is that all organisations who have been responsible for making employment status assessments as part of the IR35 rule changes will also need processes in place to respond to disputes on the outcomes they have provided. Having watched this video, your next steps in taking these actions forward should be 1. Confirm how employment status assessments will be undertaken and how outputs will be communicated to the relevant parties. 2. Determine what your process for dealing with disputes will be. And 3. Monitor timeframes to ensure deadlines can be met. You should also monitor the legislation as it proceeds to being finalised in case there are any changes to the proposed rules regarding dispute resolution. If you would like to understand any more about the actions to take next, or have any other questions on the content in this video, then please ask your usual Deloitte contact, or alternatively, contact one of the partners listed on the Journey to April 2020 website.